proceedings and rulings shall be availed upon payment of the requisite court fees as the case may be. That's the ruling of the court.
Much obliged, my lord.
My lord, on behalf of the petitioners, we have listened to the ruling. We have got no problem with the feasibility of each one way or the other. We leave it to our clients the decision whether or not they will appeal the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never uttered. Be that as it may, I believe since we received some communications from the Deputy Registrar and there were certain other pending matters in the files that were under consideration, we shall await the directions of the court before, from the petitioner's point of view, we can say one or two things. I do not know whether Afisins as my learned senior, Honorable Mwiche, has anything to add.
My lords, your leadership, we appreciate that this honorable court of its own volition has granted leave to appeal. Speaking for myself, obviously the decision is that of the client. So I will be advising the client, but it is for the client to make the final decision. But in fairness to me as counsel and other counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this court. It is damaging to counsel, and that is an issue that definitely needs to be taken out of the record of this court by the Court of Appeal. It was a very unfair accusation. Thank you.
May it please the court, on behalf of the respondents, we thank you for the timely nature of the delivery of that ruling to allow this matter to proceed. We note that you have permitted the parties leave to appeal, and we support that. The respondents support a fair resolution of this dispute in accordance with the law, and therefore we would not oppose their right to appeal. Having said that, however, and in reference to my learned friend, Mr. Peter Mundai, who has alluded to other petitions pending before court, it is the respondent's position that we should exhaust all matters today relating to the matter that has been called out by your clerk or your legal assistant. I apologize to the lady, so that we may exhaust that, after which the court will give directions on any other matter that may be before you or may be anticipated to come before you. Thank you.
That was coming up to
My Lord, my lady, on behalf of the National Assembly, I wish to express our gratitude for the very clear ruling that the court has given this afternoon. The ruling has dealt conclusively, not just with the matters that were contained in the application that was hurriedly filed and responded to yesterday afternoon, but indeed some of the other peripheral issues that the petitioners unfortunately took a lot of court time yesterday to deal with. My Lord, my lady, the National Assembly has filed an application dated the 18th of October 2024. And I believe that application was referred to in the ruling a few moments ago. That application, subsequent to the ruling that you have just delivered, I submit is the next issue that the court should deal with. And just to put it on record, my Lord, that we are ready to proceed with that application this afternoon. Members of the court will recall that last week on Tuesday, on the 15th of this month, at an hour not very different to this, when it suited the petitioners to have their application for conservatory orders heard, they insisted on it being heard. And we request that the urgency in this matter remaining and having been noted by the court, we proceed with the hearing of that application, which has been fully responded to, immediately after this. I'm most obliged.
My lords and your leadership, further to that, for Senate, I wish to state, my lords and your leadership, that unlike the petitioners, we are willing to argue the application in a record 30 minutes. Yes, the application dated 13th October 2024. We will only ask for 30 minutes to exhaust our application. We will dive straight into constitutional principles. We will not take much time. The respondents can have as much time as they want so that this matter can be concluded. My lords, Mr. Hilda has talked about the gallery of Paul Winter Senior Counsel. From that side, it was apparent that they were not just addressing the court. They were addressing other matters.
Do we need to engage? Do we need to engage in arguments on that? I was answering the question.
And my lord, we are ready to proceed.
Stop exciting me.
I will draw the remark that the petitioners are addressing the public gallery today.
My Lord, my Lords, with your permission, my lady, yesterday we were barred for being part of these proceedings. We have seen communication that we are now legally here. We have stopped mourning. Could we be allowed officially by these files being called so that we are together? We still feel that we are excluded when we are before you. Our files, there is petition file E570, E550, E541, E572 that are supposed to be before you. That we complained to the CJ in the morning, and the CJ has directed we appear here and be part of this mosaic. Kindly, let us be part of it.
Your Lordship, equally, I rise as the advocate appearing in E509 and associate myself with the submissions made by my learned senior counsel, Paul Moite, and the ones made by my learned friend, Senior Cuban.
We need to be part of this discussion.
Your Lordship, to the best of our knowledge, in the matter E015, when we broke yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday indicated to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated, and now E565 consolidated, and we have been issued the notice that my friend Mr. Omari is referring to, that he also seized of 4 other matters: E570, E550, E541, and E572. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in respect to those particular files. I hope the court is in possession of this notice, so that the court may refer to the same. Subsequently to which your Lordship will be seeking your guidance on how we deal with the applications filed therein. For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We would wish that subsequent to the court addressing and acknowledging that the other files before it, that I get directions on how to dispose of my application, for which your Lordship, the application was served. I wish to take directions exclusively and specifically on that particular matter.
My lords, may it please you, I hate to interrupt, but this is most unprofessional. We are all counsel of some reasonable experience. We all appreciate, some of them here are very senior advocates, very senior counsel. The file before the court is the only file in which you can make an application. The court cannot make orders in files that are not before it. All these files physically brought to the court are not before court. They will be before court when they are called out by your legal assistant as being available for the court to make orders. We therefore object to this manner of conducting these proceedings. It is our very humble submission that it is yet another attempt to delay the expeditious disposal of this matter.
Your Lordship, very briefly.
If I may, my lord. There are matters that you have certified as urgent and that you have identified as being urgent. And I say this with a very heavy heart. My learned colleagues for the petitions have been engaging in this dilatory tactic since yesterday. There are 2 applications before you that are certified as urgent. There are several other matters that have applications that perhaps have not been certified as urgent. Perhaps your lordships may be kind enough to deal with those urgent applications, and these matters can be dealt with later on. The files may be here, but they are not before the court.
Yeah, your Lordship.
Can counsel on this side be heard?
Yes.
Counsel on that side appears to be taking the whole afternoon. Please.
Just speak, Mr. Mute. If you want to be heard, just speak.
My Lord, I'm asking for equity of arms. Afford time to counsel on this side to address it.
You also just stand and speak.
My Lord, I think for purposes of clarity, yesterday when we started hearing on the issue of validity of the bench, which has now been discussed by the ruling you've read, the question that we wanted was the application for the validity plus the issue to do with the recusal be had together. The understanding of the court and ourselves was that they cannot be dealt with together. So that the second preliminary issues after the issue of the validity of the bench has been disposed of are the 3 pending, are they 3? Actually, I know I'm about to. 3 applications for recusal. Those are preliminary issues and they relate to the same consolidated matters that this court has given a ruling on. That is issue number 1. Issue number 2, my lord, that is important to be noted. Yes, the consolidated file that is before you has that applications for recusal. That's what my learned colleague is emphasizing. So the second business of the court was supposed to be that one. But more important, my lord, so that we do not want to hear these accusations about, oh, somebody is trying to delay this matter. We are the victim, and I reiterate that. For purposes of the petitions before you, we would like this petition had as of yesterday. And we kept on saying yesterday, the petitions to be had. My lord, these rules, because it's the enforcement of the constitutions, the Mutunga rules applies. Since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond even to the petition to get the matters rolling. there have been no compliance with Mutunga rules for purposes of the respondent. So that if anybody was to be accused of any delay, it would be somebody who has not complied with the Mutunga rules. That is issue number one. Issue number two, my lord, was this, that even for purposes of consolidation, the consolidated matters, some of the advocates led by my colleague, Ms. Kimotho, they were not even served with the applications that the respondents are itching to have them disposed of. So that, my lord, because of that mess that was created as of yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situations where some of the advocates in the four matters that were not there yesterday have not even been served with this notice, and I know them. So that unless now we take a fresh date without somebody waiting to say that, oh, this court must discharge orders and we have a swearing in over the weekend, the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, oh, I want to lift the conservatory order and the other side is delaying, it is unfair. We want the petition heard, and it starts with compliance with the Mutunga rules, which there is no compliance whatsoever by the respondents. So that, my lord, I beg you that let us not appear now to be saying, oh, somebody is playing to the gallery. Nobody is playing to the gallery. We just want to assert everybody's rights. And these rights are very easy to enforce if the Mutunga rules are going to guide these proceedings. My lord, I beg you to have the
Your Lordship, I had just wanted to highlight the content of the notice which you received.
I think and Your Lordship, we want to talk about that.
Your Lordship, the question that was raised.
Talk about that notice before you speak.
My lord, do I have your permission to address the court?
Even if the court wants to talk, you will have to talk. Dr. Kamima, let me address the issue.
Oh, I'm sorry.
Yes.
I apologize. I apologize.
I think we have made it very clear in the ruling which I have just delivered that the matters before this court are very important to the people of this republic. And you will appreciate that petitions are still being filed throughout Kenya. When we retired yesterday, we received several empanelment of matters of which we gave this notice. Therefore, don't think you are the only person who are in these petitions. There are also other Kenyans who are coming day in, night out. So the matters which you've set out for mention are the matters in which we have been empaneled as from yesterday. So you wait for court to give directions, then you start talking. You cannot just start talking from the air without facts. Let us mention these files first, then from there you'll see the directions emerging, and then you can make your prayers. Let's mention these files first. The other clarification is that we have two cohorts of petitions which have been consolidated. The first cohort were the petitions which were filed to challenge the processes both in Parliament, yes. And during that time, this bench consolidated 6 petitions, with the lead petition being 522 of 2024. Is that correct? That petition, number 522 of 2024, is the lead file in the petitions which were filed before the finalization of the matters in the Senate. Then, after the proceedings in the Senate, other petitions were filed. And with you, we consolidated all those petitions yesterday. So we have 2 running parallel petitions before the Senate proceedings and after the Senate proceedings. You will remember that petition number 522 was, we listed it for a mention on 29th of this month. But because of need to know, because I know there could be cross-cutting representation in these petitions, we decided just to call it because we knew that all of you will be here, so that if there's anything you want to say on those petitions, you can say it. So that's the reason why we have petition 522 here for a mention. There's nothing to be mentioned, but we said since parties are likely to be here, and some of the parties were even asking for it yesterday, so we brought it. But the other petitions to be mentioned are specific petitions where we have been empaneled. And we wanted to find out the way forward, whether we can consolidate these petitions or whether they can be done separately. So these are petitions number, let's mention petition number 570 of 2024, AD by Guru and Victor Gatia. Yes, this petition.
Yes. Rather than
let's meet. Yes.
Manager, in this petition, this one was filed by the law firm of, I believe, Mutembei and Maret, Mutembei, Gachagua and Company Advocates. I am aware of this petition for the simple reason that he had requested me that when it comes to the hearing, I appear alongside him. Mr. Mutembei Marete. My Lord, the parties are many, starting with the first respondent, I think is President Ruto. Rigathi Gachagua is the second respondent, and there are others. My Lord, for purposes of this petition, it was filed on Friday, and by Judge Mamuye, referred it to the Honorable Chief Justice, and we expected it to be coming tomorrow on Thursday. My Lord, Mr. Mutembei was not served with this particular notice that is before you.
Actually, nobody was served. We sent out the notice in the morning today.
Yes.
We received them in the morning. And that's why I said that this matter is people coming.
Yes.
And because the representation is likely to be across, we mentioned them because we thought we would find people like you waiting for them.
Waiting for them, yeah.
Yes.
So, my Lord, in that case, what I would ask the court, and for the additional reason that I am aware that in that matter the notice of motion is seeking a 5-judge bench, and particularly for the reason that this is an application by the citizens of Central Kenya who says, like in the year 2013, that their rights, not just regarding Gachagua, would have been affected adversely by the impeachment of the Deputy President Gachagua, and therefore I would ask that this matter do come tomorrow so that the issue on that issues of empanelment and in the presence of Mr. Mutembei can be dealt with. Because now that it is obvious that even the direct, like the advocates who filed the case are not here, it would only be fair that there is another mention where they can also be there. Actually, we didn't even have the file We are just looking at it from our record. But that is the position as far as 570 is concerned. It's a specific application for a 5-judge bench in that matter.
Mr. Kibe.
Yes, my lord.
We are beyond that. There was a request for a 5-judge bench.
Yes, my lord.
But what has been empaneled is a 3-judge bench,
yes,
comprising Justice El Kugola, Justice Mrima, and Honorable Dr. Justice Freda Mugambi. So the request for a 5-judge bench, I think, is overtaken by events unless he wants to appeal.
Yes. The chances of appeal are very high. For the simple reason that will become apparent, I believe there must be some mechanical applications to the issues that now that it arises specifically, that issue will be addressed and the Chief Justice will have the relevant communications tomorrow morning, while given the nature of the issue that must be dealt with, there must be a 5-judge matter. All benches can be expanded. I believe that is the positions that we are coming from. So without saying specifically that we don't want anyone, all benches are capable of being expansion, particularly bearing in mind, and this is something that a number of the clients that already we are representing, there have been repeated insinuations by our people out there, including Senior Counsel Abdel Abdullahi, that the senior bench is supposed, the 3-judge bench is supposed to do this or the other. We can't help that. This is not coming from the petition.
What we'll do is that we'll mention this matter tomorrow.
I'll appreciate what time alone.
At 9.
Most of that. Most of the people actually here, we have served them, but we shall serve the notice of hearing. The notice of hearing for the mention tomorrow at 9. I thought, my lord, the time would have been easier, because by the time I go to my office, there will be nobody to do some of this. So probably forever.
You know, but the time we spend here means that even if you come at 10, you'll find us here.
My lord, what time then do we come tomorrow?
The court starts at 9.
Yes.
You can come at 11.
11, most of us.
My Lord, I am asking, please, in this particular file, that you record my presence together with the other lawyers I mentioned earlier as appearing for the Deputy President who is the second respondent.
This one?
Yes. Yes.
You didn't stand up with something. I thought you were not here.
No. My Lord, patiently wait.
This matter of 570.
Yes. If you look at the parties, the Deputy President is the second respondent.
So you agree with the directions which you have given today?
I accept directions of the court. And I will be here tomorrow at 11. Inshallah.
Mr. Lordship, in this particular matter,
Yes, the same matter.
yes, my name is Manzo. I'd wish to go on record for the first interested party.
Your Lordship, my lady, may I be placed on record for the second and the fourth interested party? And permit me to only indicate the implication of the orders of the empanelment that were issued by the judge who directed the Chief Justice does empanel you. To the best of my thinking and knowledge is that the prayer was granted as it is for the empanelment of five judge bench.
Yes. We speak from the record. You heard me mention the parties. I said that this file has been empaneled to comprise the Honorable Mr. Justice Eric Ogola, the Honorable Mr. Justice Murima, the Honorable Dr. Judge Freda Mugambi. I think that's very clear. We are only three.
That's correct. But we'll address it tomorrow on that issue.
My lord, my lady.
So we mentioned it tomorrow. So you say you come to for which parties?
Your Lordship, I appear for the second and the fourth interested party.
My lord, if I may make a request. My lord, there is a file that is lying before you. And that is petition number 565 of 2024. We have requested, my lord, that you give directions in respect of the applications in that manner, because this process of taking quorum might take some time. And there are three cohorts of files that are before you. And if I may just be given a moment to explain myself. As the court has correctly identified, there is a cohort of files that are consolidated in petition 522. There is a cohort of files that is consolidated around petition 565, which have the two applications that the court has identified as urgent. And then there are these others that have been referred to the court by virtue of the email that we have all seen today. It is my request that the court keeps them in those cohorts so that the applications are able to be dealt with because they are urgent. These are important, but the applications are urgent. And the court has identified that urgency. Because this will go on for 2 or 3 hours without any directions having been given in 565.
My Lord, could we be on board together? We are being made orphans. The state is in the bedroom. Let us also be in the bedroom so that we can respond.
What do you want to do in the bedroom?
We will discuss the instruction of our plan. Kindly allow the parties to come on record.
The reason why we are mentioning this is to find out if any of them would arrive for consolidations in this matter, which is here, so that we don't duplicate.
Thank you, my Lord.
My lord, perhaps as you consider that, let me put it on record that if you are considering whether they are right for consolidation, the consolidation should not then slow down the hearing of the application that you have already identified as urgent. If they are to come on board, they come on board and proceed from where we are.
No. Yes. Let us be on board first. We'll respond to him appropriately. Yes. Allow us, even the LSK former president, to be on record.
My lady and my lords,
Excellency.
I just have a passionate plea to make. There are not many pleas. The first plea is this: could we consider utilizing the ceremonial court in the ground floor? Because it is spacious and sufficient to hold all of us. That's number one. Number two, my request is this. The court has all the petitions. Why can't the assistants to the court enumerate the parties there in the quorum, in the manner we used to do in the Court of Appeal before? So that when we appear here, at whatever time you indicate, we just fill our respective names, and the courts will be able to deal with the matter without the need of this back and forth. Number three, my lords and my lady, I think the court needs to just be a little bit proactive. When you retreat, you may make two decisions. One, either to determine the interlocutory applications, in which case you can frame issues for the parties to submit on. Or two, if you're minded to hear the petitions themselves, then still frame the issues and forward it to us so that we're able to make progress. That way we'll make good use of the initial time that is very limited in respect of this matter. I I beseech you, vote.
Thank you, Mr. Harvey. Well taken.
Former chairman of the society. Let me second the first issue and plead that if only for the purposes of everybody getting sufficient oxygen, because we are too crowded and the people want to listen, and the media and the members of the public, if it is possible, let us use the ceremonial hall. Thank you.
Council, Senior Council, we will use the ceremonial hall as from tomorrow.
Thank you.
And
I wish to say that perhaps when giving directions, then and if parties, files are going to be consolidated, then it will be proper each person is served with the applications so that we are able to respond, even if we are given a day to respond, so that when we begin to submit, we are able to submit according to the law, not as per the bar and whatever issues are being raised. Thank you.
thank you.
My Lord, I was going to beseech the court, if we are to make progress, I will beseech the court to invoke its powers under Section 55, Article 159, we could go on and on. There is no shortage of legal provisions enabling this court to rein in on the lawyers. Because if you don't do that, my Lord, on a matter like this where you have 20 lawyers, 50 lawyers on the other side, we will be coming to you, we'll be doing legal gymnastics, legal ping pong, what I call legal sophistry on other occasions, and meanwhile we'll be lamenting as we are not lamenting for you. So there are applications both from this side and this side, certified agent. Meanwhile we are spending a lot of time, each of us from whatever side, studying to raise this or other housekeeping issue. I beseech you, my Lord, in a matter like this, the court must be very firm. It must run the council. The court itself must have very clear direction. Which is the application that will be had, in what sequence, what are the time allocations, how the parties share those times. It is not business.
We have agreed on that, and what we ask is let us mention these matters so that you know how they relate to the other matters which are before the court. So we have mentioned 570.
My Lord.
We have mentioned
Mine is, my Lord, 570. 570 still, my Lord. In E570,
This file is already consolidated under the cohort of 522.
It is not.
Tell the court. Is it with the petition? Give it.
No, I'm sorry, my Lord, that was not.
yes. 550. Who's in 550?
550. Are we in that?
Mine is 550. My Lord, mine is 572.
That's it. 550.
Yes, my Lord, my Lord, with all of you, we appear for the first respondent.
I guess you can tell us who is the advocate.
The petitioner, my Lord, is the former Deputy President, my Lord.
My Lord,
represented by my Lord Senior.
my Lord, I appear for the Deputy President, not former. He remains in office on the basis of the conservatory orders, and each bench has confirmed weighty issues, which is why we are here. Let's not join the rush.
For the first petition.
For the first petition. I thank you.
My Lord, if it pleases you, Nyamodi and Gumbo for the second respondent. And our learned colleague, Mr. Murugana.
My name is Mukende. I appear together with Ms. Angie and my senior Professor Jenga for the third and fourth respondent.
Yes. Who else is in So, for the petition, what are the issues in this matter? And then
The petitioner's advocate is here.
There are so many files here. The same team of lawyers, including myself, that I gave when we came for the ruling, is appearing for the Deputy President this matter.
Yes. Is it going to be consolidated only to some alone?
It's not one of the ones that we are consolidated, I believe.
No. Sorry if I appear. For you to be able to progress, I beseech you to adjourn this matter tomorrow. Go and make directions. You're either hearing the petitions or the applications. Come here so that we have a perspective upon which to progress. Otherwise, we will not progress.
We are aware of that fact, Mr. Hart, that
it's my advice.
It is the councillors who will be saying that there has to be hard.
Yes.
Even on petition, that is issue has not been granted. Therefore, let us agree on the way forward. If you make a proposal can come from you your side, how you want to deal with all these petitions. Is it possible that you want to ignore all applications and proceed the petitions? You can make a submission to this court can consider.
My Lord, if I may, just to guide the court on this account, I will do it as soon as My Lord, the urgent application before you. The applicant for the petition has applied yesterday on a preliminary objection to the application that was filed before you dated 18 October 2024 for discharge of the whatever decision this court makes can be either way. We need two directions on the hearing of all the consolidated petitions. Some of the petitions deal with issues
they're asking
or go to the versions of the law before the laws impeachment. The proper position of the law is that the party who is the petitioner is the former deputy president. That's the position of Article 145(7). Allow us, my lords, to urge our application for the setting aside of conservatory orders. I think, my lord, that's the only way we can move, because the about their bite, let us have our bites as well. We will only take 30 minutes, we request.
I'm not disagreeing with you, Professor Jenga. What I'm saying is that let's mention these files.
Yes.
We are on the third one. And if you have been interrupting, perhaps we can do with them. 550.
Yes.
What I asked, is this file related to the files before the court? For the purposes of consolidation, or it can stand alone.
Can we deal with that tomorrow? My lord, tomorrow. We only do the quorum. Because I need to. We just do the quorum. We only deal with the quorum.
Start of time to go through.
Consolidation has implications. I need to consult my team. I need to consult the client. Let's take the quorum. Let's deal with the consolidation tomorrow.
We'll mention it tomorrow.
Yes.
That's why we should have a plan in order for all of them to be mentioned tomorrow.
Dr. Clarence Eboso. Dr. Clarence Eboso.
My lords and my ladies, my name is Banjiro Mondi. I am acting in person, and I am the second petitioner in the matter. The first petitioner, Dr. Clarence Eboso, is online, my lord, and my lady, my lords and my lady. And I believe he want to say something.
May it please the court. My name is Dr. Clarence Eboso. I'm the first petitioner in E541. The petitioner is between Dr. Clarence Eboso, Ms. Wanjiru Mwangi, versus the Speaker of the National Assembly, the Attorney General, and with the Law Society of Kenya as an interested party. The petition relates to the process of impeachment, particularly in the National Assembly, and seeks orders to quash the proceedings in the National Assembly. The petition has an application which was certified urgent and which sought an injunction against the entire proceedings of impeachment. The court which certified it urgent directed that the application will be heard by the bench that will be constituted. Several of the prayers that were made in the application have since been overtaken by events. However, the substance of the application sought to conserve the issues as they were, and therefore the conservatory orders that were issued by the court in last week on Friday protected some of the prayers that we had made in the application. Yesterday I pointed out in the court that proceeding with the discussions on the conservatory orders would have prejudiced us, because then we would have lost out without participating. Our prayer would be...
It's not taken, Cora. No.
We take Cora. Is that in the application? We are taking so long.
Just tell us, Clarence, whether this petition, you want it to stand alone or whether you want it to be consolidated with the petitions for the court.
That's where I was going to go.
Let's go there, yes.
We will be seeking that the petition be consolidated with the petitions relating to both the impeachment process and the filling of the vacancy that arises from impeachment. The reason being, upon filling of any vacancy.
Okay, we have had you agreeable to the petition being consolidated with the petitions which are in file number 565 of 2024.
My Lord, may I just conclude? That I will be willing to compromise our application, provided that we can be allowed to participate in the applications for conservatory orders that are before the court.
My Lord,
in the interest alleged time.
With your permission, my Lord, I appear for the first respondent in the matter.
You don't agree?
Yes, and my Lord, I note that we didn't come with our file.
Is this petition post-Senate proceedings?
No, my Lord. It has no connection with the post-Senate. It was filed, my Lord, before. And it has not touched on issues, my Lord, that happened at the Senate. Ordinarily, my Lord, would be opposed.
So we mentioned this matter tomorrow. We mentioned this matter on 29th, where the petition number 522 will be mentioned.
Most of likely.
My Lord, tomorrow or on the 29th?
29th.
My Lord.
Yes.
I'm not sure if the court got the last statement I made. It would be very prejudicial to us if the discussions relating to the conservatory orders continue without our participation, because we are essentially raising the same issue in our application.
My Lord, I agree, as we filed our application on the 8th of October 2024, before the National Assembly had even made its impeachment, had impeached Deputy Brigadier Gachagua, my Lord. We are acting in person, we are laymen, my Lord, and we are also protected by the same laws, Article 27, Article 47, 48, and 49, and 50, my Lord, for the right to a fair hearing. So we do ask the court does mention our matter tomorrow, so that we can articulate the points that we need to.
My Lord, I appreciate the fact that the petitioners are appearing in person. My Lord, once the court has made an order, my Lord, the only remedy available to the parties is either to appeal. We have not made any order.
We mentioned this matter tomorrow.
Next one. Interesting party. That's it. 5 seconds. Why don't you say it instead of explaining to me and I'm No, you say it.
Yes. My Lord the Presiding Judge, my Lord and my Lady Doctor, if it pleases you in the matter, my name is Wamboi, Shadrach Wamboi. I have the honor and privilege of introducing counsels for the petitioner. I appear alongside my learned senior, Mr. Dunstan Omari.
I'm present. Only one interested.
Mr. Samson Nyaberi, my senior.
I'm present, my lord.
My learned colleague, Mr. Nicholas Karanja.
I'm present.
And my learned colleague, Miss Melissa Omeda. We all appear for the petition applicant. Thank you.
My lord, in that matter, I am Shadrach Mose, the Solicitor General, appearing for the Attorney General, together with Professor Gitu Muigai, Senior Counsel, Emmanuel Peter,
Deputy Chief State Counsel, Charles Mujinda, Deputy Chief State Counsel. Much in favor.
My Lord, there is a busy the matter. Miluma, my Lord. I appear alongside Ole Buyoni for the first respondent.
Very busy, my Lord. For the second respondent, my name is Bumbo. I appear together with my learned senior colleague, Mr. Paul Nyamoli, and Mr. Honorable Itonga Murugara.
Great peace, my Lord, my lady. That matter, my name is Edwin Kelly. My Lord, I appear together with my senior Professor Ojeda. My Lord, Senator Hilary Sigay, and Ms. Mercy Tangi for the third respondent, my Lord, in respect of this matter.
Yeah, and it's
for the third respondent,
the Deputy President is the interested party, and I appear with my colleagues, Mr. Ngoya, Mr. Tomacharia, Jomo, Devwa, Sakimpa, Wandati, Victor Swanya, Faith Muge, Faith and Mr. Muge, for the interested part, that is the Deputy President.
Thank you, my Lord. My Lord, just to respond to the question whether this petition should be consolidated with the others, the questions that have been posed in the instant petition question the constitutionality of the impeachment process at the Senate that led to the removal by way of impeachment of the Deputy President. Secondly, my Lord, it also questions the constitutionality of the appointment of Professor Kithure Kindiki as the Deputy President designate in that office. And for that reason, my Lord, the view that we take with humility is that the petition is ripe for consolidation, and my Lord, just for the avoidance of any doubt, and my lady, we have an application filed and dated the 18th day of October 2024 that sought an order of conservatory order to stop the implementation of the decision made by the Honorable Speaker of the Senate, Honorable Amason Kingi. So, my Lord, when we canvass, or we are to canvass the applications as to whether the current conservatory order should be disturbed or not, we want to actively, and we seek with humility, to participate in those proceedings. Thank you.
Mr. The parties, are you opposing the possible consolidation?
Yes, my Lord, we are vehemently opposed, my Lord, to the joinder or intended consolidation of this petition. And also that we don't take time before you this evening, we would prefer, my Lord, that this matter also takes the cue of being mentioned tomorrow with the others, my Lord, where we will substantively, my Lord, be presenting my lord before you reasons why this matter should not be consolidated with the one that's before you today. And my lord, so that we save time, I speak for all the respondents. And then the other sorry, my lord. You mentioned tomorrow.
My lord, if you permit me. My lord, there is a mischief that we need to cure or to safeguard ourselves against. My lord, there is an attempt to have a litigation by way of installment in this matter. So much so that, my lord, if you look or you find time to look at the petition and the application, you will see that the issues that are raised by my seniors and counsels for the petitioner are synonymous, they are the same.
Since it is not consented to, what will be listened to tomorrow?
Most obliged, my lord, because the question of consolidation is a question of law and it's purely on a principle.
They can do it.
And my lord, we will be ready to argue the question of consolidation as and when we are invited. Thank you.
They can also do it voluntarily.
Yes, yes.
Is it tomorrow?
And my lord, my lord and my lady, yes, I am guided by my senior counsel Paul Witte. The question of consolidation is one that even the bench, as it is currently constituted, can actually look at the matters and on its own motion, suo moto, give directions or orders whether it is deserving to be heard alongside the other matters or we just need to take a cue behind other petitioners, my lord.
My lord, the court has spoken. You mentioned it tomorrow.
Let's consider that.
Most obliged, my lord. Thank you.
Has the senator become a court assistant? We are in for the petition.
This one has a mention date for 29th of October, but because issues are arising, we wanted to mention it again today if there is any issue arising out of it.
In terms of appearances, and in order to the court's time, the same counsel that I enumerated are appearing for the petitioner, the deputy president, in this matter.
Yes, my lord, for the respondents, the quorum is similar, my lord, so that we save on time. My lord, we will be willing, my lord, to present the proposal. Either, my lord, will share the mentioned date that has been given, or, my lord, you mention the matter tomorrow, so that if there is anybody who wants to address, the address is tomorrow.
We don't want back tomorrow on so many matters. If there's no need, we can attend the 29th.
So this is 29, yes. Don't agree to have the matters.
Yeah.
Yes. Yes.
So we are clear with the mentions. We can go back to your petition and our advice.
No, Your Lordship, you have not mentioned my matter. 5 to 9. 5 or 9? Sorry, I'm sorry, I never heard you call it out. I'm sorry, Mr. Kip was keeping me busy giving me. But my lord, in that respect, we have an application in the National Health Exam record. We could also mention and get directions tomorrow on my application for the recusal of the bench dated the 22nd. I would be most obliged, Lordship. Most obliged.
So then we have petition number 565.
We wish to confirm that on the part of the Attorney General of the Republic, we are ready to argue our application satisfies argument by this court or by the court referring the matter to this court.
I believe this is a matter that we had earlier on indicated that after all these matters have been consolidated, directions have been given in these matters, specific directions need to be given for purposes of that matter. And for purposes of the levy, those specific directions to be given, I want to point out 3 things. Number 1 is that we would need directions on when the first application that was to be done after the validity application is determined, when we are going to be had. That is issue number 1. Issue number 2, my lord, that is important, is the fact that now that today the Honorable the Chief Justice has caused all of us to come on the basis of these other matters, the point needs to be noted that for purposes of the basis for all these matters that empanelment is done, the reason was that there were applications for conservatory orders. Those applications for conservatory orders were first certified as urgent and would be the first business of this court appearing there, assuming there is no other preliminary issue like recusal or other ones. Thirdly, my lord, is this, that for purposes of those applications where conservatory orders were made, the conservatory orders may have been made in 2 or 3 files, but they conserve the status, quo that is cross-cutting in all the petitions that are before you. Apart from the fact that in that particular petition, the one that has conservatory orders, when this court, because all those applications were done on Saturday, the parties, starting at least with those that I represent, because of the nature of the proceedings that were there yesterday, we have not completed doing the responses to the applications by the Attorney General to lift conservatory orders. We could not be able to do the authorities for reasons that were indicated, and more importantly, my learned colleague Mrs. Kemodo, whose file has been consolidated, did indicate she has not even been served, and in that matter, she needs to respond and be heard. Therefore, my lord, in considering this issue that is itching the group that wants lifting of the orders, I would like the court to give directions bearing in mind that the stakes of the parties, all the people who have filed petitions, is to ensure you are not faced with a fait accompli, where you are told we have already sworn Kindiki and you can go to hell. We do not want to be faced with a fait accompli situations. My lord, it would be absolutely important that the subject matter is preserved, if not for any other day, until all the parties are before the court. Yes. Your Lordship. Your Lordship,
Proceed in these matters as follows. By tomorrow, we will issue comprehensive directions on various issues, but importantly, parties are already aware that there are two cohorts of matters. The first cohort involves the petitions which were filed challenging the happenings before the National Assembly. Those petitions will proceed as cohort 1. They are the subsequent petitions which were filed challenging what transpired in the Senate. That is cohort 2. By tomorrow, we will deal with the issue of consolidation. We are aware of the powers this court has on the issue of consolidation, just like how we exercised the powers yesterday. We may decide to either hear or give directions on the consolidation. However, we are in agreement that the next application in line can only be one, and it is the application for recusal of this bench. And that is the application which, after we do everything, tomorrow at 2:30 is up for hearing. If you intend to participate in that application, in the second cohort, that application is coming up for hearing tomorrow at 2:30. In the morning, we will deal with the issue of consolidation. That one we will give directions on that. So that is the way forward. Prepare to hear the application for recusal of the bench tomorrow at 2 p.m. In the morning, we will deal with the procedural issues of consolidation and any other issue which may arise in cohort 1 and cohort 2. Thank you.
Directions, my Lord, your leadership, and we entirely agree that we will assist in the orderly progression of the hearing of these matters. Thank you.
Just for the record, my Lord, we assume it is all the 3 applications for recusal because
there will be no other application for recusal. You will hear what is on record and it will